Thanks for coming into the air conditioning. I'm sure you all mind. Welcome tonight to the Andrew Breitbart Freedom Center here at the Heartland Institute. My name is Jim Lakely. I'm the Director of Communications here at Heartland, and we're a 32-year-old think tank until almost exactly a year ago. Was based in downtown Chicago, and now we're based here in this beautiful building in the northwest suburbs of Chicago in Arlington Heights. Our mission since our founding has been to discover, develop, and promote free market solutions to social and economic problems, to fight for policies that shrink the size and the scope of government, and to increase individual liberty, and to encourage prosperity through vibrant free markets. Heartland covers key aspects of domestic policy through our centers: the Center on Budgets and Taxes, the Center for School Reform, a center we call Consumers for Healthcare Choices, and our Center for Environmental Policy, and our newest center, the Center for Constitutional. We are amazingly effective in our mission, is the Heartland Institute. As they say, you are known by your enemies. And judging by social media, ours are mad all the time. So if you like what you see tonight and you like what you're watching here on our live stream, I encourage you to look around at heartland.org, which is very, very close to a brand new redesign, which I hope you all will enjoy and find more useful. You can check out our blog. You can check out our daily podcast on iTunes called the Heartland Daily Podcast, which gets almost, or a little more than 1 million downloads every year, so join the informed army on that one. And check out our YouTube page where you can see presentations like this one here tonight and the other ones we've had here in our event space, plus lots of policy videos as well. I think you're going to see a lot that's to your liking. You can also talk to a Heartland staff member here, and they can show you how you can browse books in our new Michael Perry Mazer Memorial Library. It's got more than 10,000 volumes, and we believe it is the best collection of free market and economic books anywhere in the Midwest. And I think you would agree, so please feel free to browse that after the event tonight and talk to anybody here. Also about donating books. If you have good books about freedom and liberty and economics, and even biographies of important people in those movements, somewhere in a basement or an attic, or if you lent it to your Uncle Ned and he didn't give it back to you, give him a call and get that book in here, and it'll be used and be read as research, not only for the people here at the Heartland Institute, but students around the area and professors as well. It grows every day. We want to keep it growing at that rate. And also, please note that the early bird rates for our annual benefit dinner, which is September 15th at the Cotillion in Palatine, Illinois, featuring P.J. O'Rourke. The early bird rates end July 31. So you get a 20% discount if you order your tickets or tables before July 31. So I hope that a lot of people here in this room, if you have not yet signed up for that fantastic event, you will do so and get a nice discount. And we've also announced, or just confirmed, frankly, that conservative icon Morton Blackwell has agreed to accept the Heartland Liberty Prize this year. He's trained generations of champions of liberty, and so come help us support him and his important work and help honor him and the work he's done through a lifetime. And if advancing freedom is important to you, we'd love to have your support so we can keep informing the public and elected officials, like Tom Morrison over there, about free markets and the importance of maintaining liberty and our free choices, which includes, as you might note, a right to own property, which brings us to our discussion here tonight. So the right to ownership is one of the most essential of human rights, but how is that right supposed to be protected in the Constitution? And how can ordinary property owners help rein in an ever-growing a government that is ever violating our right to private property? Those very good questions will be answered tonight from our guests, our tonight's speakers, Timothy Sandefur and Christina Sandefur, the authors of Cornerstone of Liberty, Property Rights in 21st Century America. Now, this was published in the wake of the Supreme Court's landmark Kelo versus New London decision, which I understand official GOP presidential nominee Donald Trump is a big fan of. But they wrote that during that whole firestorm in the interest of protecting property rights. And it's now in its second edition, which brings them here today. And it's been fully updated by Timothy and Christina, and examines how dozens of new developments in courtrooms and legislatures across the country have shifted the landscape of private property rights since that 2005 decision. Through a combination of real-life stories and solid legal analysis, the book explains how key issues like eminent domain, civil asset forfeiture, which is a big issue here at Heartland, and environmental protection regulations, another big issue here at Heartland, have evolved and how they should be reformed. Speaking first will be Timothy Sandefur. He is Vice President for Litigation at the Goldwater Institute and an adjunct scholar at the Kelo Institute. Before joining Goldwater, he served for 15 years as a litigator at the Pacific Legal Foundation, where he won important victories for economic liberty in California, Missouri, Oregon, and other states, and participated in many significant eminent domain cases, including the aforementioned Kelo versus New London. Christina Sandefur, who will follow Timothy, and then we'll have a Q&A here, is the Executive Vice President at the Goldwater Institute. She also develops policies and litigates cases advancing healthcare freedom, free enterprise, private property rights, free speech, and taxpayer rights. Christina has won important victories for property rights in Arizona and works nationally to promote the Institute's Private Property Rights Protection Act. The state-level reform requires governments to pay owners when regulations destroy their property rights and reduce their property values. Ladies and gentlemen, it is my pleasure to introduce Timothy and Christina Sandefur.
Thank you. Thank you all very much. It's an honor to be here. This is my first time in the Chicago area, the only major American city I've never visited before, so I've really been enjoying seeing this city. I want to talk tonight about property rights from an angle that maybe you haven't thought about property before. And that is when we talk about what it means to own something, whether it be a huge plot of land, or whether it be a small token that means a lot to you sentimentally, like your wedding ring or something. When we talk about private property, we tend to think about things. And instead, I want to take a moment to think of it in terms of what does it mean to say that you possess something, to say that something belongs to you. As I see it, we're unfortunately moving in a direction in this country away from the idea that ownership or possession is a right, and toward the idea that ownership or possession are permissions, that they are a group of privileges given to you by the government. And that dilemma, the difference between rights and permissions, is essential really to what it means to own something at all. And when you look at the history of property law, what it means in the Anglo-American common law principle that we've adopted and modified to the present day, you see that difference between permission and right constantly at work in the history of our tradition. And you see it particularly nowadays when we lawyers, we like to talk about the difference between the nuisance system and a permit system. The legal principle of nuisance is the idea that if your neighbor is using property in a way that substantially interferes with your ability to enjoy your land, you can go to court and sue him. And you can get damages or you can get an injunction to stop him from doing what he's doing on his property that's interfering with your rights. And the principle that's at the heart of the idea of nuisance is, of course, being a lawyer, I have to say it in Latin, sic utere something, 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 I don't know Latin. But what it means is you have the right to use your property as you choose, as long as you respect other people's right to use their own land as they choose. And the short form of that, sic utere, is the principle that we call it. On the other hand, there's the permit system. Under the permit system, you're not allowed to use your property at all until you get some kind of permission from whoever's in charge, right? So, and if you think about it, this pervades virtually every aspect of our lives today, not just property rights, but your right to own a gun, your right to get a job, your right to basically to do a tremendous amount of the things that you do today requires some sort of permission from the government. And when you apply for a permit, a lot of different principles apply that are very different from the nuisance system, right? First, the presumption in the nuisance system is that you have the right to do what you want with your land, unless proven otherwise, unless you hurt somebody. Under the permit system, you are presumed not allowed to use your land until that's proven otherwise, until you prove to the government that you should be allowed to use your land. So it's, in that sense, it's completely the opposite. And how do you prove that you should be allowed to use your land? Well, you have to justify it according to some criteria. The government says you have to come in and prove the following things before you're allowed to do what you want with your property. And that means that the burden is on you to satisfy these criteria, and those criteria are often phrased in very vague terms. Terms like, is there good cause? Or is there, reasonable need? Or in the business world, we talk about certificates of public convenience. Have you proven that there's a future public need? Right? What does that mean? How do you prove a future public need? How do you prove what is a good cause? These sorts of things. They're so vague, that vagueness gives a lot of power to the bureaucrats who are in charge. There's also the problem that we economic-minded people refer to as public choice, the problem of rent-seeking. If the government has the power to take wealth from some people and give it to other people, that power is worth a lot of money, right? If I have the power to redistribute $10 million, that power is itself worth at least $10 million, right? So the people are going to invest their time and energy and efforts in trying to persuade me to give them the $10 million. So the public choice, the effects, the rent-seeking that permit systems create, because a permit is worth a lot of money, that's what causes lobbying and private interest lawmaking. Then there's the knowledge problem. The problem that nobody knows how people should be using their land. Nobody knows the answer to that question. Nobody knows how to regulate an economy in the right way, right? The example I often give, imagine I first went to a Starbucks in 1993 when I was on a trip in Seattle, Washington. Now, if somebody had told me at the time, hey, this place, this Starbucks is going to be wildly successful, it's going to take over the country, I would not have believed them. I mean, who needs to spend $4 for burned coffee, right? Well, it turns out that the world really did need a new chain of overpriced burned coffee places. We know that because Starbucks is so successful. But if you hadn't had to prove that to a group of bureaucrats in 1993, you couldn't have done that, right? So the knowledge problem, nobody, least of all the government that doesn't have any incentive to get the answer right, nobody knows how to answer the question of how should property be regulated, who should be allowed to build what, where should things be built. Nobody knows the answer to that question. The only way to find the answer is to try the experiment and find out. But the permit system doesn't let you try the experiment until you satisfy the bureaucrats' demands. And then there's what I consider to be the most fundamental problem about the permit system. And that is, what is the difference when you get to the bottom of it between a permission and a right? Some of the young people in the room know the answer to this question right away, because they don't have rights, they only have permissions. When you ask for permission, you have to ask somebody above you. You're not asking somebody, you don't ask an equal, a person who's your equal, you don't say, please respect my rights. No, you expect them to respect your rights. That's what ordinary decent people do. But when you're asking permission, you have to ask somebody above you for permission to do the thing that you want, in contradiction to the basic principle that all men are created equal, which underlies our entire legal constitutional system in this country. And of course, if you have to ask somebody for permission, that gives them the opportunity to demand a little backsheesh in exchange for that permission, right? That's why you find the more permits a system requires, the more times you're demanded to get a permit, the more opportunity there is for payoffs of some corrupt kind, right? Bribery and that sort of thing. Now, to put all these principles I've been talking about into perspective, consider a case from 1987 called Nolan versus California Coastal Commission. Anybody in here from California? I'm from California. The California Coastal Commission is the most anti-property rights bureaucracy in the country, which dominates control over the use of land along 800 miles of California coastline. And one of the things that it does is it pushes its powers to the ultimate limit every single time it gets the opportunity. In the 1980s, the Nolan family, which owned a small house in Malibu, they wanted to put a second story on their house. So the commission came to them and said, okay, we'll give you a permit for that, because you have to get a permit from the commission for basically any development on the coast. We'll give you that permit, but in exchange for that, you have to let the public walk across your backyard to the beach whenever they want to. And the Nolans said, what's the connection between these two things? We want a permit to renovate our house, and they're demanding that we give them an easement across our property. That case went up to the U.S. Supreme Court, and the Supreme Court agreed with the Nolan family. They struck down that requirement. And they said, the government can require something from you in exchange for a permit, but only where your development is going to cause some kind of harm. And the government says, okay, but you have to ameliorate that harm. The government can't just use your permit application as an opportunity for extortion, for saying, okay, well, in exchange for the permit, we want a little something from you, right? That was what the Supreme Court said in 1987. And since then, city and local officials have been doing their utmost to evade and ignore this ruling. Not just a couple years ago, I can't remember now, I think it was 2 years ago, the Supreme Court of the United States decided a case called Koontz versus St. John's Water Management District. This case was shocking. What happened there? Mr. Koontz wanted to develop his property in Florida, and the government said, okay, it was about 15 acres or so. The government said, okay, but you have to give us 11 acres of it in exchange for permission to use the remaining 4. And Mr. Koontz is an elderly man. He needed to make money off this property as quickly as he could. He said okay to that. So then the government said, all right, and also we want $500,000 from you to rebuild some, or $200,000 from you, to rebuild some property on land located 5 miles away from his land that had nothing to do with what he was doing. That went up to the Supreme Court. It took 2 decades for the Supreme Court to decide that case. They finally ruled in favor of his family. He had died by that time. And said, no, the government can't literally demand a cash payout in exchange for a permit that has nothing to do with what you're doing with your property. Now, that's what happens when we're talking about permits. But when we're talking about something even more brutal, eminent domain, the situation is just as bad. When it comes to eminent domain, what the government is doing is it's coming to you and saying, we demand that you give us your property. We're demanding the title to your land. Now, the Constitution, I'm sure you all have your copies of the Constitution with you, so if you'll take those out, I always use my handy Constitution iPhone app. It was updated the other day, and I don't know why. Probably, to put Obamacare in there, probably. Anyway, the Fifth Amendment allows the government to take property through eminent domain for public use if it pays just compensation. Now, what is a public use? Railroads, airports, right? You could probably come up with a long list, but the one thing that we know for absolutely certain about public use is it's not a private use, right? That's the only thing that's absolutely clear about the meaning of the phrase public use, is it's not a private use. Nevertheless, in 2005, the Supreme Court said in Kelo it was okay for the government to take away private property from one person and give it to another person solely for that person to use for private development, because in the long run that will enrich the community. And the Supreme Court opinion in that case really boils it all boils down to one single sentence in that opinion. There's a sentence where Justice Stevens, who wrote the opinion, says, economic development is a traditional and long-established function of government. There's no footnote, there's no citation for that claim. He simply asserts it. Now, if you look through your Constitution, economic development is not to be found in there. It's not in the Declaration of Independence, which declares that the reason we create a government is to protect our rights, right? Economic development is not a traditional and long accepted function of government. It was adopted into our system by the progressive movement of the late 19th, early 20th century that decided that government exists to make society the kind of place we want to live in. And if doing so means violating some people's rights for the benefit of other people, you gotta break some eggs to make omelets, right? I've always seen so many broken eggs. Never once have I seen an omelet. I'm speaking metaphorically. Well, that was the Kelo decision, and unfortunately, that is the law of the land in this country today. The Supreme Court made clear in the Kelo decision that states were free to set higher standards if they chose to protect private property rights to a greater degree than the Supreme Court was willing to do. And to talk a little bit about how that works, I'll introduce my wife, Christina Sandefur.
All right, thank you. Well, for those of you who are active in the states or who follow these issues, you probably know there's a happy ending to this story, right? We all know what happened after Kelo, and that was we had an immense public backlash. This was not a Republican or Democrat issue. It wasn't a left or right issue. It was a people issue. It was a property issue. And people realized that when the Supreme Court says that government can come in and take private property for private use, for private companies, that anybody's home is at risk. And so people ran to their state legislatures to answer the calling that came from the Kelo decision. And they said, please pass laws to protect our property rights so that people can't just come in and take our property away. And most states actually did that. For those of you who keep count, it's about 47 states now that have passed post-Kelo reform laws that say that government can't come in and take private property for private use, something that really should have been apparent to government and the Supreme Court from the beginning, but nevertheless, states came in and solidified those protections. So, end of the story, we can all go home now, right? Unfortunately, no, because that's not how the story ends. That's never how the story ends with government, right? There's always some postscript that we have to talk about, and this one is actually pretty serious because although, yes, most states are pretty clear about protections and what it means by, what the Constitution means by public use, government has found loopholes. See, people are very entrepreneurial. People find way around regulations, but government is very entrepreneurial too. Government finds loopholes in restrictions on their power, and it's able to come in and restrict your property rights even after laws are passed that say that it can't do that. There are two primary ways that government has violated the legal protections that were put into place in the states after the Kelo decision. One of them is the blight exception. Now, government has the power, at least in many states. There are a couple states that have prevented against this too. I'm proud to say that Arizona, where I live, is one of the states that protects your right against this misuse of power. But there are a lot of states that say, well, look, if a neighborhood is blighted, government can come in and it can condemn homes and it can take your private property. And the reason is because that's a public use, right? If there's blight, then it's government's job to come in and clean that up. Now, if we think about that, I'm sure you all kind of have a picture of what is blight in your mind. And let's see if it looks like mine, something that is a health hazard, something that has fallen into disrepair, right? Something that really poses a health and safety risk for the neighborhood around you. And we might be able to agree that, yeah, to some reasonable degree, government should be able to come in and prevent that. Well, what is the government's definition of blight? That's a good question. It's whatever the bureaucrats say that it is, right? It is very broad. In many states, it's not defined, or it's defined by very, very broad factors that have to do with things like economic blight or economic situation. What does that mean? That means lower class neighborhoods. That means the government can come in and wipe out lower class neighborhoods in order to replace them with upscale housing or development. And gosh, doesn't that sound just like the Kelo case? So really, that is quite a loophole around those types of protections. In fact, the government did this in the city of Lakeview, Ohio. If any of you have ever been there, you might have seen what used to be a charming little middle-class neighborhood. Looks to me kind of like the American dream. Well, government officials drove through there, and they said, you know what, this neighborhood is blighted. We got to take this, and we have to put in upscale housing. Well, what exactly did they use as a factor to determine that it was blighted? Well, the houses didn't have two-car garages, and they didn't have central air conditioning. That was enough for the homes to be blighted. Now, I grew up in the Midwest. I grew up in the Detroit area. We did not have central air conditioning where I grew up. You all well know that central air conditioning is quite a blessing this time of the year, but I did not consider my home blighted. And it's sort of offensive to me that the government would think that it was. But nevertheless, that's what happens with these types of loopholes. An even bigger problem, though, is regulatory takings. Most of these protections, in fact, almost all of these protections don't account for so-called regulatory takings. Well, what's a regulatory taking? In an eminent domain case, as bad as it is that government can come in and physically take your property away from you, take title to your property, at least we know it's very clear that the government has to pay you when it does that. Now, it pays you something called fair market value. What is fair market value? Well, that's a fancy legal term, but it's really hard to arrive at that amount, right? Because fair market value means whatever you would offer your property up for sale, And since the government has to come in and steal your property from you, that means you're probably not offering it for sale, and whatever they give you in compensation is probably not appropriate or fair. Nevertheless, that's about the best standard that we have, and that's what the government uses when it comes and takes your property by eminent domain. Well, what about when the government comes in and regulates your property rights away, but doesn't actually take title to the property? So the government says you can no longer use or build upon or rent out or even sell your property as you see fit after you've purchased it. Well, what does that do? That, reduces the property value and takes away your property rights, but it still leaves you with title to the home, which means it leaves you with the mortgage payments, it leaves you with the bills, the insurance, it leaves you with the taxes, exactly, and it leaves you with the liability. If somebody comes onto your property and gets hurt, right, you're still liable, you still own the property, but of course the value now is decreased. If you did try to go sell it, you probably couldn't recover all the cost or the worth of the property. And if you go to court, like you would in an eminent domain case, to say, hey, government took away my property rights, they've taken away the value from my property, most of the time, the judges are going to say, sorry, you're out of luck. You still own the property. You can still do something useful with it. And as long as you can still do something useful with it, even if it's not what you wanted to do with it, well, I guess that's how it's going to be. You don't get to recover any money at all. That is a serious, serious problem, and it is a serious loophole and an abuse of the government takings power. Let me give you an example of how this works in the modern context. We're going to talk about a client of mine at the Goldwater Institute. His name is Glenn Odegaard, and he lives in a small little town of Jerome, Arizona. Now, if none of you are from California, I doubt any of you have been to Jerome, Arizona. Oh, look at that. Every time we give a talk, I ask if someone's been to Jerome, Arizona, and every time somebody has. So that is amazing. Quite a few of you. That's great. Jerome, Arizona. Where is Jerome? Well, Jerome is a couple miles north of Phoenix, so the Phoenix Valley area. It's absolutely beautiful. It's known as America's most vertical city because it's perched up on the side of a mountain. And it used to be a mining town back in the day, but about 50 years ago when the mine shut down, a lot of people fled to find jobs, and the town had to sustain itself. It only had a couple hundred people left, and it did so by turning into a tourist town. So there are a bunch of really cute stores and restaurants, and there's some historic artifacts. There's a jail that's actually sliding down the side of the mountain that you can go see. And a lot of times people come and they stay there, and they use that as a jumping off point to go to the Grand Canyon or to go to Sedona or to see some of Arizona's other beautiful landscapes. Well, Glenn is from the Phoenix area in Arizona, where Tim and I live, a couple hours south, and he fell in love with Jerome when he went up there. He said, this is just the neatest town. I wish I could have a home up here, but of course my business keeps me down in Phoenix, and it's expensive to keep up 2 homes or to purchase 2 homes. So he thought, well, I'm going to look around, just see if I can find something. Glenn looked around, and he came across Home Sweet Home. What did Home Sweet Home look like? It was a dilapidated building that had been left vacant for 60 years after rocks and mud had come down the side of the mountain. A tree was growing out of the middle of it, and there were all sorts of interesting Arizona desert vermin crawling around it. That was Home Sweet Home to Glenn. Why? Because Glenn's an entrepreneur. He's a visionary. He actually fixes up buildings and homes for a living, and he said, if I buy this property, which frankly isn't going to be very expensive, it's not worth much, and then I put money into it, and I put my time into it, and I restore it into a home that people can come and enjoy, I can recuperate those costs by renting it out as a vacation rental. People who want to come stay in Jerome can stay there and enjoy the town like I do, and then on the weekends or whenever I can come up and I'll have my second home in Jerome. It sounded wonderful. So that's exactly what Glenn did, and he turned this building. He took it from a health hazard, turned it into a historic beauty. It actually made its way into the cover of Arizona Highways magazine. It's featured on the Jerome Historic Buildings Walk. It really is a beauty. And if you go to our website at goldwaterinstitute.org, you can see before and after pictures that are just absolutely incredible. Well, how did the town reward Glenn for rescuing this dangerous building and turning it into something beautiful? They called him a criminal, because what the town of Jerome did is they decided, after Glenn had purchased the property, after he had put his blood, sweat, and tears into restoring it, that they would outlaw short-term rentals. And they wouldn't let anybody rent out their property for under 30 days. And they would punish people for doing so with fines and jail time. They would give you a criminal record if you were going to rent out your property. Well, again, as we know, going to court usually means that you're out of luck in that type of situation. And so when asked to justify their actions, why exactly did the town do this and why are they turning responsible property owners into criminals? The town gave these reasons, and you really can't make this up. They said, people from out of town who stay for under a month, they're not going to know where the potholes are in Jerome. Those of you who have been to Jerome, you know there's a lot of potholes. We're not going to fix the potholes, but what we're going to do is keep out-of-towners away from the town because they're not going to know where the potholes are. They could get hurt. It would be this whole thing. It's for your protection. They also said, people from out of town don't know when trash day is. And so if you're staying in the home for under 30 days, I imagine they think their visitors can't read, then they won't know when to put the trash out, and they'll put it out in the wrong day, and the javelina will come and take away the trash, and it will just be a terrible situation. Can't do that. And then my favorite reason was, we really need to make sure there are enough long-term houses open for the people who want to serve in government. So in other words, got to make sure the bureaucrats have their houses, and as long as they have their houses, then maybe we'll think about everybody else. Even though the lifeblood of the town, of course, is tourism, and even though without Glenn's being incentivized to fix this home up, it would be a health hazard, right? But that's what the town did. That's the town's thinking. Now, I wish I could say that Glenn's situation was unique and you never hear about this, but all you have to do is open up your web browser and search home sharing or Airbnb or HomeAway or something like that, and you will see dozens and dozens of cities come up that have recently regulated or banned out of existence home sharing, renting your home for a short time. In New York, the legislature actually just passed a law that says that not only can you not rent out your home, but they will fine you $1,000 if you advertise the rental of your home. That's because, as you can imagine, it's kind of hard to tell whether people are renting their homes or not. It's hard to tell whether you're just letting your friend sleep on the couch or whether you're actually renting it out to somebody. And gosh, if you're going to make money from it, then it's illegal. And we're going to go online. We're going to violate your speech rights. We're not going to let you share any information. We're going to fine you $1,000. That's how New York's dealing with this. In Hawaii, it's actually even worse. Everywhere in Hawaii, short-term rentals are illegal. And again, very difficult to enforce. People have a hard time paying the rent in Hawaii, and so some of them are still renting their homes. And so they have sent, the city of Honolulu has sent people out to the beaches to interrogate guests and to ask them, exactly where are you staying? Are you staying in a short-term rental? Are you sure that you know the people who live there? Interrogating people, ruining their vacations, and then fining homeowners up to $10,000 a day for renting out their homes on a website like Airbnb or VRBO. Absolutely crazy. The city of Santa Monica in Southern California recently passed a restriction like this. They estimated that it would cost $500,000 for the first year to try to enforce it. And after about 1 year and 3 months, I just saw an article the other day that they finally caught their first criminal. They finally found somebody who was renting out their homes. They fined him, they threatened him with jail time, and he has a 2-year probation period now because he pled guilty. 2 years probation. He is now a registered criminal. He said, I'm going to leave the state of California. I've lived in Santa Monica for over a decade. If this is how they're going to treat me, I'm leaving. I'm going to move to Colorado. This is a major, major shift from our founder's vision of private property rights, like Tim was mentioning, right? This is the very definition of shifting from a society that views property rights as a right and that you should be free to use your property as you see fit unless you're hurting someone else, to a society that views property as permissions. And the government gets to decide whether or not you get to use your property for a certain purpose. And if the government decides that it's not a good idea, then it can take away your property rights and it doesn't have to pay you. Now, of course, sometimes we hear the reason for banning short-term rentals and things like that is that, people don't want noisy neighbors, or they don't want trash, or they don't want traffic problems. And although the statistics don't really show that short-term rentals add to that, it's completely understandable, right? Those are the types of things that government is supposed to regulate. But instead of regulating those things, in other words, enforcing noise ordinances, enforcing trash ordinances, enforcing traffic ordinances. What is government doing? It's just banning activities outright because it's easier to force you to ask for permission or to not let you exercise your rights at all than to have to deal with the consequences when occasionally there's a bad actor, right? We don't ban all backyard barbecues because one of them might get noisy every now and then. We don't say you can't have a birthday or pool party in your backyard because some people might park where they're not allowed to park. No, we presume that you're free to do those things. And then if you do something bad, as a result of that, then the government comes in and it enforces its ordinances. But that's not the society we live in now. So what can we do about this, given that we have strayed so far from our founders' vision? Well, at the Goldwater Institute, we've decided that we really have to change the rules of the game, and we have to change the way that bureaucrats think about regulations. Now, I wish that we could just give them a copy of the Constitution or have them download the Constitution iPhone app, but something tells me they probably won't read it. And if they do, they probably will ignore it. So instead, we have to change the rules. At the Goldwater Institute about 10 years ago, we came up with something called the Property Ownership Fairness Act. And it's really, really simple in concept. It just says that when the government takes away your property rights, whether by eminent domain or by regulatory takings, it has to pay you for doing that. Imagine that. Now, government bureaucrats say, well, gosh, we shouldn't have to pay to regulate. You know, we might not regulate as much if we have to do that. We might not have enough money. They really do say this. But of course, if government wants to act in a way that protects your health and safety, truly protects your health and safety, things like noise and trash ordinances, it can do that. It doesn't have to pay for that. But if the government wants to go above and beyond, and it wants to tell you that you have to set aside part of your property for a wildlife preserve, or you can't rent out your property to overnight guests, or you can't paint your house yellow or something like that, this law still allows them to do that, but it has to pay you for taking away that property right, because that is a right that you have as a homeowner, as a property owner. It's just as simple as that. It has changed the way in this decade since we passed it about how bureaucrats think about regulations, and sometimes in Arizona, bureaucrats decide that it's not worth the money to regulate. And we just say, look, if it's not worth it to regulate, then certainly the property owners themselves shouldn't have to shoulder those burdens. If it is something that's worth it to the community, then the community ought to pay for it. It's as simple as that. Now, we've done really well in Arizona. We've passed this law. We've passed a law to help out people like Glenn in the Airbnb type of situation that says that cities can't regulate vacation rentals, or they can't ban vacation rentals outright. Instead, they have to target their regulations toward actual health and safety. And these, again, are changing the way that government thinks about property rights and thinks about the way that it regulates nuisances. I would love to see the state of Illinois pass such a law. I'd love to see every state pass such a law. It's going to be an uphill battle. But at the Goldwater Institute, we're dedicated to sharing the successes that we've had in Arizona. We want to see every state protect property rights. And we're hoping that by changing the rules of the game and by forcing bureaucrats to think about the consequences of their regulations, that we will once again restore property rights to their rightful place, the cornerstone of liberty. So thank you very much. We'll be happy to take your questions.
Great. And I was in a good mood about 15 minutes ago, I tell you. Not your fault, not your fault. It's bureaucrats' fault. You know, they say that the government that's, most local governs best and all that stuff. Well, petty tyrants are also in every town around the country. Anyone who lives with a homeowners association probably knows that. It's time for Q&A. Please raise your hand, and a person with a microphone will come to you, and he will hold it for you in front of your face, so that it'll be well heard by everybody. Larry, raise your hand even higher. That'd be better. So it's easier for Kyle over there to see you, or for Ariana there to see you. She'll come over. And I also want to recognize Joe Bass, the president of the Heartland Institute, is here today. He might ask a question as well, so that's great. I have a quick question. Is Santa Monica mostly Democratic or Republican? Just curious.
Santa Monica. Oh, can you hear me? Santa Monica is a very liberal community.
Yeah, I used to live in Southern California. That was a trick question. All right. What about Honolulu?
Yeah, it's pretty blue itself.
Okay. And then that in Arizona, that town, I'm sorry.
Actually, the sad thing about Arizona, and this shows that it's really a bipartisan violation, is that town is fairly red.
Yeah.
A lot of Arizona is fairly red, so it's not just a Democrat problem.
Yeah, I mean, that was kind of the point. I think it's bipartisan. You give people a little bit of power, and then kind of sometimes goes to their head. I think it's human nature. So, all right, ready for Q&A from people here in the audience. Oh, I'm sorry. And then online, if you're online, we're looking at you on the chat room here on the YouTube page, and plus we're also trying out Facebook Live right there. And so we have someone in the back checking for questions on that as well. So, Larry from Ariana here.
So in numerous well-run, nonpartisanly governed suburban communities around here, there are what are called apartment ordinances. And what has happened is that not by bureaucratic fiat, but by local ordinances, they pass a law saying that an apartment owner who has already been renting out his apartments has now got to qualify, has got to be certified as a proper owner. He's got to go to class, pay a fee, et cetera, et cetera, et cetera. And in places that I'm aware of, I won't mention any particular suburb, they generate quite a bit of money. And the pretext for this was they were going to hire an extra cop by doing this, whose presumed role would be to go around and look for miscreants in apartment buildings. So here you have not just bureaucratic discretion or indiscretion, you have laws that are passed where people hardly notice it.
Yeah, absolutely. And it's a really great example of what we were just talking about, that, you know, we look at the state or the federal government or bureaucratic fiat as being the real violators of rights, but, you know, in this case, local officials and local control and even democratically passed ordinances can be just as bad. And that's why we need to look to the Constitution and also have these state protections to really enforce these rights. You know, it's interesting. You can tell how these bureaucrats get smarter, or city planners get smarter, because they try to justify their actions as if they were health and safety or protecting the public. That's what the officials did in Jerome. Quite laughable, but that's what they were trying to do. And that's what it sounds like they're trying to do here when they say, well, look, we're going to have additional police protection, so that's why we have to charge all this money. If that were really the case, and one might be able to see on some grounds how that might be justified if they could really show that there was some sort of increase in crime, then simply they would ask people renting out their homes to just pay a reasonable fee to be able to do that. And it would be sort of like a shall issue permit, you know, with handguns, right? That you would just, no matter what, you'd get permission to do it as long as you paid the fee to make up for the additional police needed. But that's not what they're doing. They're making you go to classes, go through the rigmarole. So again, this is clearly something that's disguised as health and safety. And in Arizona, that wouldn't pass muster. And that's why we need these state reforms.
One thing that it brings to mind is, you know, a lot of the time, the regulations of apartments, the excuse is often given that it protects the renters, to, you know, against evil slumlords and so forth. But in fact, a lot of the time it has a regressive effect that harms them. And there was a Supreme Court case just a year or two ago where some groups are suing because the communities impose such a harsh, such a stringent inspection and enforcement requirement on apartments that as a result, there were fewer apartments, and that was harming the poor and members of minority groups. So they brought a race discrimination lawsuit saying it was having a disparate impact on minority groups for the city to so heavily police code enforcement. And it was. And the Supreme Court said, yeah, they can sue over that if they want. And that case has gone back to trial court now.
Disparate impact is another abuse of government.
It is. It is. It's just I kind of like to see it used against the government.
And I also forgot to mention, please identify yourself for your question so our guests know who they're talking to.
Vicki Comerford, the Heartland Institute. I had a friend in Chicago who the Northeastern University took the whole block, told them, too bad, we want it for student housing, even though all the businesses on the block showed them, you own this property over here, empty property, vacant property that they had, and the university said, no, we want this property, and took the whole block by eminent domain. Too bad for them. How do you combat something like that?
Unfortunately, not just education, but any use of property that courts think is closely related to education tends to get away with whatever they want. And even if it's not actually being used for educational purposes, the government can use that. And it goes beyond eminent domain. Why don't you tell the story about the property developer who's trying to fix up the houses out in Tucson?
Oh yeah, so in Tucson, there's an example of a university area. The University of Arizona is out there, and there are a lot of dilapidated structures and a lot of need for student housing that the university wasn't providing. So a private developer said, I'm going to go restore these buildings, make them beautiful, and then solve your housing crisis that you have. And instead, again, the city came in and said, well, you know what, there's an anti-demolition ordinance we're going to put into place. You can't knock down any historic structure. Now, those of us who are from the East sort of laugh when they consider a 1950s building and a historic structure that hasn't been updated since the 1950s, but nevertheless, that's what it was. And so again, our Property Ownership Fairness Act came into place, and we said, well, if you're going to tell me you can't knock down those buildings and fix them up, then you ought to pay them for that. And again, the government didn't feel it was good. The government decided it wasn't worth paying for that. So instead, he got to build his buildings and solve the housing crisis. So again, you've got to change incentives to be able to get government to behave well. It's not going to do it on its own.
Got a question here, David?
Yeah. David Perrenboom. I'm just wondering if you guys are familiar with a book titled Takings, and I can't remember the author. He's at the University of Chicago, professor of law. Wrote
You're
the
thinking
book
of Richard Epstein's
Richard Epstein.
classic 1985 book,
I'm
Takings.
just wondering if you'd comment on whether it's, for a layperson, I'm not a lawyer, worth reading. But
I find Epstein sometimes difficult to follow, even as a non-lay person. Epstein is a genius. I admire his work tremendously, and you all might actually remember the Takings book from Clarence Thomas's confirmation hearings, when then Senator Joe Biden held up a copy of the book during the confirmation hearings and demanded to know whether Clarence Thomas was now or ever was a believer in private property rights. Anyway, Professor Epstein is a remarkable mind. He's, if you've ever had the privilege of hearing him speak, he speaks in these perfectly formed paragraphs that, I mean, literally, he dictates his books. And that book is a very sophisticated and fascinating book, but I would not recommend it for laymen. The book I recommend for laymen other than ours, of course.
I was hoping you'd get there.
And that is cited several times in the book, is Richard Pipes's wonderful book, Property and Freedom. Richard Pipes is a Harvard professor and an expert on Soviet history, on the history of Russia and the Soviet Union. And he took time out to write a one-volume book on private property rights about 15 years ago, which is just marvelous, and we relied on it heavily in writing.
One more quick book recommendation. Another one we cite in the second edition is Jeff Benedict's Little Pink House. Now, it's not a policy book; it's a story about the Kelo case, but it's really, really instructive. And I think a lot of times stories make our arguments better than the actual legal arguments do. So check that out as well.
Yes, it's called Little Pink House. I definitely, Jeff Benedict is the author, and I wish I had thought of that. Book came out after the first edition of our book came out, and so we basically rewrote our entire book in large part because of his.
Got one over here.
Hi, my name's Dan Robin. I think the pink elephant in the room is, I think it was Proposition 207 that got you this law. How the heck did you guys get it passed?
Yeah, that's a really, really great question. We had a lot of support from people who believe in private property rights, which was really helpful. But Proposition 207 was a voter initiative, and that is something, sometimes I look at Arizona's progressive constitution and I say, gosh, we shouldn't be able to amend the constitution just because a bunch of people vote for it, except that it actually has turned out to be pretty good in Arizona, because when you get the word out about private property rights, people tend to respond, and that's what they had done in Arizona. One of the things that really was helpful in passing Prop 207, the Private Property Rights Protection Act, was that we did it right after Kelo. So it was very visceral to people, and people understood that property rights aren't this tool for the rich and the wealthy and the well-connected. In fact, property rights protections are needed most when you aren't rich, when you aren't well connected. And they knew Suzette Kelo's story, and they responded to it, and we were able to show them that regulatory takings can be just as bad. We sort of are facing an uphill battle now because the Kelo case is 10 years, 11 years past, and people don't remember it as well. People have short-term memories, and I actually think that the stories about people wanting to rent out their homes would be, are things that will cause people to again remember the importance of private property rights. You hear a lot of New Yorkers say that we wouldn't be able to pay the rent if we weren't able to make a little bit of extra money by renting out a room or a couch or our home when we're out of town. And I think that will help us, along with support of people who believe in private property rights, to be able to pass this law in other states.
Can you explain what Prop 207 is to people who may not be
Prop
familiar?
207 is the Private Property Rights Protection Act, which we're now calling the Property Ownership Fairness Act. It's what I mentioned in the talk, the law that says that when government takes away your property rights by eminent domain or through regulation, it has to pay you for the reduction in property value that is the result of taking away those rights.
And it's Arizona.
And it's right now it's Arizona only, but it's a law that could be passed in any of the other 49 states.
Right here. David?
Dave Shostokis. Often, your friend in Jerome, is there an established hotel-motel industry there? And is often some of these regulatory takings not really for safety reasons, but to protect established other industries from competition?
Now, why would you ever think that? How would you go there? Come on now, people aren't like that. Yes, so it's interesting. We find that there are usually two reasons for these types of regulations. One is that the established hotel-motel industry doesn't like the competition that comes from Airbnb or private people renting out their property, because, of course, the hotels then can't charge you an arm and a leg for staying there. They're no longer the only gig in town. Another reason, though, is sometimes neighbors who really have a strong desire to keep the neighborhood as they've always remembered it. Now, we can understand and sympathize with that. It's hard sometimes when a store that you've gone to forever is replaced by a Walmart, or people that you've grown up with move out of a neighborhood and new people come in. So you can understand that sentiment. But the problem is, and this is what primarily happened in Jerome, it's not a proper role of government. It's not something that people should use government to do to keep what they consider undesirables out of their town, especially in Jerome, when of course tourism is the lifeblood of the town.
You got a question right here?
And just quickly, that goes back to the nuisance permit thing that I was talking about, because there are already rules on the books that prohibit, loud noises or irresponsible parking or whatever in these neighborhoods. And when these communities say, "Oh, we're going to prohibit short-term rentals," what do? You're going to hire a cop whose job it is to go around and peek over people's backyards to see if the person back there is just the sister-in-law or some stranger that's pending money. If you have the money for the cops, why don't you enforce the existing nuisance laws? Right?
Yes.
Identify yourself, please.
Some years ago, in 1972, I was in the Soviet Union, and I met Alexis Tolstoy. His father is a famous Russian writer. And he told me a story where somebody wanted to build a dacha, and he wanted to build a house on on the land. The land never would be his, but he would have a right to the land. And then the house would actually be his. Well, he got permission to build a 6-room house, and after he got all the permissions, he built a 11-room house, doing just what he felt like he was going to do. And basically, the land effectively was his, even though he didn't own it. Just a comment, that's all.
Yeah, well, this is not untypical. When you have a society where people have to get permission before they do things, it gives power to the people who stand above and decide who gets permission. They get all sorts of authority that, a lot of the time is not written down anywhere. So it's kind of nudge, nudge, wink, wink. In the Soviet Union, they called it the nomenklatura. The nomenklatura could get what they wanted, and the ordinary folks couldn't, because they had the connections, and the ordinary folks didn't. And it transforms a society from one in which the decisions are based on mutual exchanges and agreements and contracts and rights, into a society where decisions are based on who you know and who you can do a favor for and that sort of thing. It's what I call that a permission society as opposed to a free society. And the Soviet Union was probably the most heinous example of a permission society in history, at least until the rise of Islamic fundamentalism in the Middle East.
Well, yeah. And I was going to say in Hawaii, where nobody can own the land under their homes either. So there you go.
Going right there. Art?
Art Ellingson, Arlington Heights. Are you familiar with the case in the western suburbs of Chicago where there was a school board, not Wheaton, Illinois, wanted to condemn property to build a new school? And the property was owned by Wheaton College. Wheaton College is the alma mater of Billy Graham. And I went to a couple of school board meetings out there where first they tried to tell people who were visitors, like if you're from out of town, like not from this school district, you can't speak. And the first person who spoke was a lawyer who read from the school code that says you can't even ask people where they live if they want to speak at the meeting. And so there were 100 of us, basically Tea Party folks, who were there to put a stop to this. And of course, and I still don't know what happened to it, but the land they wanted to condemn was not even in their school district. Wheaton College thought it was worth $47 million. They wanted to pay $100,000 for it. And I still don't know what happened, but have you guys heard of that case where the school board actually condemned property that wasn't in their district?
I haven't heard of that particular case, but I have heard of cases in which jurisdictions have tried to condemn land outside of their jurisdiction. And of course it depends on state law, but the case I'm thinking of was in California, and that was not allowed.
Dan Robin again. Christina, when you spoke with the Federalist Society, the young lawyer that you debated that session, he raised the idea that trespass laws, trespass rules were ineffective, that they were punishments after the fact, they're difficult to enforce, difficult to find proof. And therefore, because of all that, we need all these regulations to prohibit everybody in advance for their wrongdoings. And I didn't hear it raised, but I will raise it now. This device, a cell phone with a camera, with an ability to record noise violations, other violations, now makes trespass laws far more useful and far less use or need for your rules and regulations to prevent conduct in advance. I thought maybe you could comment.
That's a really great point, and one that hadn't occurred to me when we were having that debate. My answer to him was just that sometimes freedom is messy, and basically you're either going to have a situation where you allow people to be good, responsible citizens, and then when they do something wrong, you react and you bring the police to enforce a noise ordinance or something like that. And occasionally there's going to be a couple problems with that. Or you have a society where nobody can even speak or move or use their property or take a breath without asking for permission first. And yeah, you probably prevent all sorts of bad things from happening, but guess what? Who wants to live in a society like that, right? So in this society, we value freedom as a primary objective, and that has to come first. And that was my response. But yours is very good on a practical level. And I think that the rise of technology is not only good for being able to enforce the things that you're talking about, but also, frankly, to keep the regulators honest too, right? We see a lot of times it's really hard for police to get away with any kinds of abuses, and actually it also gives police cover if they didn't do anything wrong and somebody's accusing them of wrongdoing. So technology is a wonderful thing, and once again, the market is solving government inefficiencies.
Do we have
Except to the extent that Al Gore invented the internet.
That is true.
That's an old joke, but it still works.
Still funny.
Kyle, the gentleman right there?
Yep. Okay, if you should be looking at zoning ordinances. In my city, they start out everything is prohibited unless it is specifically allowed in the ordinance. That is the ultimate of control and thereto. A second point is we need to be a little bit more forceful in our language. We need to talk about these kind of things as what they are: harassment and discrimination. And not politically correct talk about them in a wishy-washy manner.
Well, to your first point, absolutely. I mean, zoning by definition is a permission society instead of, it's especially when it goes beyond obvious health and safety regulations instead of a free society. And again, to use an example from my home state, in Arizona, we have a court rule. It's in our common law in Arizona that says the exact opposite is true. In most places, zoning says that everything's prohibited unless we allow it. But in Arizona, the rule is the opposite, which is what it should be. Unless something is specifically prohibited in the zoning code, you are presumed to be allowed to use your property as you see fit. That ought to be the rule in every single municipality in the United States.
Remember, this started out, the very idea of freedom in America started out with the rejection of the permission society principle. And I have particularly in mind two areas, and that's speech and religion. At the British common law, the principle was that the government could not impose a prior restraint on you if you wanted to speak. What is a prior restraint? It's a permit, right? The government couldn't require you to get a permit before you spoke. Now, at that time, you could be punished for what you said, but you could not be required to get a permission before you published your opinions. The First Amendment came along and it said, yeah, you can't be required to get a permit, and you also can't be punished for what you say afterwards. The other example is religion. At British common law, there was no such thing as religious liberty. There was a principle of toleration at British law. And British law said, well, we will allow people to practice their religious beliefs so long as they're Christians and not Catholics. And and Blackstone, if you read Blackstone's commentaries written in the 1760s, he's very proud of the very broad, liberal-minded toleration of the British Constitution. And he was right. At that time, it was the freest system on earth. He says, my God, we even allow Catholics to own property, which is really something. Well, when the American Revolution came and Thomas Jefferson and James Madison were writing the Virginia Declaration of Religious Freedom, they rejected the principle of toleration. George Washington rejected the principle of toleration. Thomas Paine, in his book, The Rights of Man, expressly rejects the principle of toleration, saying it is not liberty, but the counterfeit of it, because it says that the government owns the ability to give you religious freedom in the first place, which it doesn't have, which is just as bad as if the government takes away your religious freedom. Instead, Jefferson and Madison and Washington and Paine insisted on the idea of religious liberty. And there's a great story that in 1776, very shortly before the Declaration was written, Virginia held a constitutional convention where they wrote the Virginia Declaration of Rights. And they had a committee to write the Declaration of Rights. And the highly respected elderly statesman George Mason was the head of this committee. And he was drafting, he wrote up a first draft. And also on the committee was a little 20-something pipsqueak that nobody had ever heard of, a little short guy named James Madison. And this he's basically a college intern. He comes up to Mason and he says, you can't put toleration in there, which Mason had written full toleration of liberty in his draft. And Madison persuaded him to delete the word toleration and replace it with the word liberty. He was so proud of it that when Madison was in his 80s, he was writing his autobiography and he stuck that in there. So the principle of liberty as opposed to toleration, of a free society instead of a permission society, is what this country was founded on. It's the basic principle of all human freedom. And it's not just zoning or restricting the people's ability to rent out their property or to own their homes or whatever. It's throughout our society we are replacing the idea of freedom with the idea of privilege and permission. And it's a travesty, and it must be stopped.
Yeah, that's a really good point. I mean, yes, let's applaud that. Oh, my goodness. Before you put it so eloquently, I was thinking how, there's that, I don't know, there was a talk show or something, they say, there ought to be a law, and people have this idea, this mindset that if I don't like something, then it should be illegal then, because I don't think it's a good idea to do that, or I just have a personal preference and I think I should impose that on everybody else.
Yeah.
when people that are raised in liberty believe that as long as you're not bothering me, it should be okay to use my land the way I want. But people don't think that. The mindset, of the entire country is so far away from that these days. We had a question over here?
I just wanted, excuse me, I just wanted to bring it up. Going back to the principle, what you guys might want to comment on, is really we end up getting federally, state, and local, we end up getting the government that we deserve. I mean, now there's a lot of municipalities in every place, but around here, for example, just typical, that a lot of people want zoning ordinances. They want to, for whatever reason, they want a stable area that they're willing to put constraints on others so that they have the kind of climate they want. So what I'm saying, this is just a local thing, but it's everywhere. I mean, we get the government that we deserve because of what our actions are. We've let it happen for a long time. Could you comment?
That's exactly the reason why you don't find the word democracy anywhere in the Constitution, and it's for exactly what you're saying. Because yes, in many ways we do get the government that we deserve, but it's because of the fact that you can have a grassroots tyranny or a tyranny of the majority, that we have constitutional protections that keep a lot of decisions out of the democratic decision-making process altogether. So, of course there are some things that are open to democratic discussion, and there ought to be, but most of those things should be left open to individual choice. And I hear this argument all the time when we pass these laws, or when I talk about short-term rentals and things like that. People say, well, gosh, most of the people in our community, we voted for, majority voted for that law to restrict people's property rights because that's what we want. And how dare you in Phoenix tell me and Jerome how I should live my life? And my response is, well, how dare you and Jerome tell your neighbor how he should live his life? Because it isn't every single property owner in that town that is saying, yeah, we're bought into this scheme and this is what we want. It's a majority. It's 50% plus one that's saying that we want to impose our will on the other 49%. And that is not appropriate when you're talking about the use of rights. That can only be done by private assent, by contract, homeowners associations or things like that, where every single person is in agreement. And if not, you got to persuade your neighbor, or you got to raise the money and buy his house. But it's not an appropriate thing, and it's we can't assume that just because a majority does something that makes it okay.
Of course, here in the land of Lincoln, people should know that principle very deeply. That was the basic disagreement at the heart of the Lincoln-Douglas debates, was what is the limit of democracy? And Lincoln beautifully parodied Stephen Douglas's position by saying that Douglas's belief was that if one man wishes to enslave another, no third man may be allowed to object. Right? The idea that if people vote on something, well, then, that just makes it right. Well, of course that's wrong. The point is, we are free people. We are all equally free, entitled to our liberty, and that takes precedence over the majority's will. Certainly there's a realm for the majority to make decisions on who should be dog catcher, or how much the spending on the should be for the dog catching office or whatever, right? But those have to take place within a boundary, which is individual rights. The purpose of the Constitution is to protect us against democracy. If it was supposed to be just a democracy, there would be no need for a Constitution at all. Or the Constitution would be one sentence long. It would just say, majority will goes, right? Instead, the Constitution is this elaborate structure of checks and balances and limits on the states and limits on what Congress can do, and all this sort of stuff in order to hinder democracy. People dismissively call it gridlock, or say the Congress isn't doing its job and all that. That's a good thing. The system was very carefully designed just for that purpose, to make sure that many are called but few are chosen when it comes to laws that restrict our freedom.
Larry?
Yeah, let me ask a question about the permitting system and lawyerly reasonableness.
Contradiction in terms.
And maybe reasonableness is just a bad word altogether. So if we were if we had the expertise of the Amish, we could build our own houses and barns, and we would not need building permits, we would not need inspectors, because we would have that knowledge. But in today's complex society, don't we need a building permit even if we have the right by zoning or any other means to build on our land, simply because we don't have the expertise, and there are people who need to be certified so that the building won't fall on our heads and the sewage won't fall onto the next property, et cetera, et cetera. Where do you draw the line?
That is a great question. I'm really glad you asked it, because I think I may have come off in my remarks as saying that the permit system is always a bad thing, and it's not. There's trade-offs to the permission system on the one hand and the nuisance system on the other. The downside to the permit system, the downside of the nuisance system rather, is that it tends to punish after the fact, right? You can't get damages against a doctor if he kills you. Your heirs could, I suppose, but So there are situations in which a a forward-looking, proactive system is better. A permit system is required, and because the damages would be too severe if the person's bad, and so we want to make sure that they're an expert or that they're safe or whatever. The thing is, I don't see why government has to do that. There's already private alternatives that satisfy those requirements. For example, rating systems. When you buy something on Amazon or on when you go to use Yelp to choose a restaurant and stuff, people use reviews all the time. They use that way more than they use government permitting systems. I virtually never go into a restaurant and go over to the wall and read the health certificate on the wall to make sure, I looked at Yelp and I saw nobody on there said they got sick and they really liked the burrito. Sorry, burrito, I'm from Arizona. So I think there are alternative rating systems, and as far as damages are concerned, I think if there were, to the extent that there's a consumer demand for those kinds of systems, I think insurance will take care of that. Now, it's true, people are distrustful of insurance companies, and I don't blame them, but they should be more distrustful of the government. An insurance system is going to come to a restaurant owner and say, look, if you want insurance from us, you're going to have to satisfy certain safety requirements. We're going to send an inspector to check out your restaurant, make sure that you're not putting botulism in your spaghetti sauce, And I think that is the system that would work more efficiently, because another thing that we often fool ourselves in, we often think that we want a perfect world, and nobody wants a perfect world, because the only perfect world is heaven, and everybody's dead there. What we want is a good enough system. What we want is a good enough society. We want a society that's perfect enough, but also has these trade-offs. Same thing with environmentalism. We don't want a clean world. We want a clean enough world, a world that is clean, but also we have factories, right? So and the way to make that trade-off is through a market system, or as close to a market system as you can get, rather than government fiat. I think that government does have a role in environmental protection, and I think for as much as possible, the effluent into the streams problem is solved by nuisance law, and that, in fact, bureaucrats, for the most part, when bureaucrats are writing regulations, sensible ones, they look at nuisance law first and foremost, right? So I think that should be the first solution. But yeah, I think government should be in the role of ensuring that people don't harm their neighbors by polluting downstream. I don't think that the government should be in the business of making sure nobody ever goes into the forest, which unfortunately has tended to be the policy, at least since the Clinton era, among federal environmental bureaucrats. Their attitude is rope this off and make sure that no human being ever touches it, because human activity is just defined as pollution, which is the attitude you see among a lot of these bureaucrats.
Just one quick thing to add to that is I recommend it. This reminds me of a film that we actually talk about in the book. It's called Still Mine. It's a Canadian film, and I think you can see it on Netflix if you're a subscriber. It's really remarkable, because it shows sort of the other side of what you're saying, that sometimes, when we think, well, gosh, this problem is, we care about health and safety and inspection of houses and things like that, and we want to make sure people are doing quality work, so we have to have bureaucrats come out and enforce that. And sometimes the type of rating system or the private systems that Tim's discussing is actually more helpful, because we have these unintended consequences of bureaucratic regulation. And in that film, which lays this out beautifully, there's a man who's been building homes for his entire life and on his property, and it's been in his family's, it goes back generations, and he produces his own wood, and he wants to build a smaller home on his property because he and his wife are elderly and they can no longer get around in their bigger home. And so he does so, and of course the bureaucrat who's wearing the construction helmet, even though he doesn't know a thing about construction, comes to the home every single day, and he says, well, you didn't get a permit for this, you didn't get an inspection for this and that. And the guy says, I've been doing this longer than you've even been alive. My wood, my construction actually far exceeds the government standards. The only difference is that you didn't put your stamp on this. I didn't get a permission first, but if you want to test it, go right ahead. It's just as good. And the government wanted him to tear it down because it just didn't have that government stamp, even though what he built was actually better. And that kind of thing happens all the time because government doesn't have any incentive really to get it right. In fact, when government gets it wrong, it usually just uses that as a justification to get more money. We don't have enough bureaucrats on staff to be able to figure this out, so give us more money. Whereas in the private system, you know, when Zagat's rates a restaurant and then the restaurant has some sort of horrible health problem or whatever, people are not going to read Zagat's anymore unless they're really careful and make sure that they're rating restaurants in an appropriate way. So.
Yeah, no, that's a great point I wish I had remembered to say, is that when the bureaucrats are in charge of testing, remember, bureaucrats, the only thing you really ever need to know about government is that government gets paid even if it gets the answer wrong. The most important thing you can possibly know about government. So if the government's in charge of protecting safety or protecting us from, say, protecting us from Enron, how many SEC officials were fired for failing to prevent the Enron thing from happening? Enron went out of business. People went to jail over that. But when it came to the government bureaucrats who were supposed to prevent that or other frauds that we've seen in recent years, they don't get punished like that. Anyway, yeah, great film. It stars James Cromwell from the Babe movies. And but it's a beautiful, touching movie and a true story. It's called Still Mine.
We have time for one final question.
I'd like to go back to the pollution issue. To me, the issue of pollution has to do with exactly what you guys write about. That is property rights. If I pollute onto my neighbor's land, he's going to sue me very quickly. But nobody owns the ocean. Nobody owns the streams. Nobody owns the lakes. Nobody owns the air. I don't have a great solution for the non-ownership of those items. Do you?
Well, I think probably the most famous writings in this area are, you know, Ronald Coase, and even he. Frankly, I'm a little, a little suspicious of being able to impose a sort of Coasean society where we just divide up the ownership rights to everything, the air, the water, everything else, and just say, okay, well, now the market will figure it out. I think that is a difficult question. I think that until our society is advanced enough where we can figure out how to divide up ownership of things like air and water and all of that, that probably the best solution that we do have for tragedy of the commons types of situations is to have some sort of really basic reasonable rules and to have government enforce it. And this is kind of like what Tim was mentioning, is that is an area where we probably do have to have some prior rules set down. But again, that's really easy to abuse, and so we have to make sure that those rules are based on science and are based on reason and fact, and not and based on something that is reasonable, so that people can still live their lives, and not just that nobody can go into the forest. You know, nobody can ever breathe. My gosh, I'm polluting right now because, well, some of you might say because of my words, but I'm polluting because I'm breathing out dangerous gases. You know, right? And so we got to find something reasonable there. There has to be a reasonable balance. But, you know, I do think it makes sense in a situation where nobody owns anything that we have to have government rules, and that's why it's good for most things to be owned.
Yeah, and keep in mind that it's true in the abstract there are things that you don't own, but even there are things that are affected by things you don't own that you do own. So, for instance, although you don't own the ocean, you can own fish. And so if somebody's polluting an area where you have the right to fish, then that person is harming your property. And so although, if you can come up with an abstraction like, is it possible to pollute outer space? No, it's not. I would argue that it's not literally possible to pollute outer space, but it is possible to pollute Earth orbit, right? That actually has happened. Earth orbit is heavily polluted. Is it possible to pollute Mars? I would argue no. There's no human beings on Mars, and therefore it's impossible to, literally speaking, to pollute Mars. But once a person lands on Mars, once Robinson Crusoe on Mars happens and there's somebody there, then it's possible to pollute Mars, because then you could conceivably interfere with that person's rights. So the cases in which there's true non-ownership, I think, are pretty rare, and even when that happens, I think the law has the tools to prevent harms by saying, well, how does this ultimately affect the person? And there's complicated areas of water rights law and environmental law that have gotten into this. The person I'm thinking of, Terry Anderson from PERC in Montana, has written about property rights that American Indian tribes had in buffalo herds. It's true that American Indians had a very different concept of property rights than we do, but they didn't have no property rights. The whole Pocahontas Disney movie myth is nonsense. But their concept of ownership was very similar to the kinds of rights in a stream kind of concept that we have when it comes to a river, ownership of water in a river. So I do think the tools are there in the private property rights realm. Little complicated, but
Well, that's why you need to get the book.
there you go. These are all the questions in the book.
I'm a pro. I've done this a couple of times. And let's that was a fantastic discussion, you two. Let's give them a round of applause. And how about a round of applause for the Heartland staff who was here making this all run so smoothly today, please? Appreciate that. Thank you. We hope a week from tonight, Eric O'Keefe is going to be here. Eric O'Keefe speaking on the use of state power to silence patriots. If you've not heard of Eric O'Keefe, you ought to hear about Eric O'Keefe. The man has an incredible story of abuse, incredible abuse of his rights that you should come here and hear about. And also, of course, I was reading the back of it. That's why I was holding it up like that. And of course, we have our benefit dinner on September 15th, and again, early bird rates end on July 31st. Excuse me? Eric O'Keefe is next Wednesday, right here, same time, same channel, and so we hope to see you there. You can register at heartland.org. Thank you so much. Have a good night. Drive home safe.